So I'd like to introduce our primary presenter today. This is Daria Neuenhaus. She is a lawyer, and Daria's practice ranges from transactional matters to general counsel services. She has extensive experience with the merger and acquisitions of hospitals, long-term care facilities, clinics, assisted livings, home health and hospice programs, group practices, substance use disorder facilities, and other provider entities. She guides clients through the regulatory aspects of capital projects and other strategic initiatives. She is active in healthcare reform matters, and Daria is currently working with clients on ACO matters, clinical integration, affiliation, and similar arrangements. In addition, as if that didn't keep her busy enough, Daria provides experienced counsel in the areas of contracting, patient care, risk management matters, privacy and security of patient information, and addressing adverse events, including crisis management. In addition, she's developed this sideline of trying to make sense of the rules of medical marijuana. So we are very honored to have her here. To get us started today, I want to introduce our title, Marijuana Home-Based Care, Street Drug, Medication, or Something Else. And I want to dispel a myth right up front. If any of you think you came in here because in an hour you're going to be able to walk out and go, I get it, I understand it, I'm good to go, forget that. Really, what we are going to do for you today is illuminate a whole lot of things we don't know and hopefully start a conversation. This presentation actually started from a member calling me up and saying, so now I'm in a medical marijuana state and I have a patient who proudly gave us their medical card. What do we do now? And she and I began a conversation about what do you do now? What are the operational implications of a patient with a medical marijuana card? What are the documentation implications? Is it a medication? Does it go on the med list? That means it's going to get printed on the plan of care and sent off to a physician who's not probably going to sign it. If it goes on as an over-the-counter, how do you put in things like frequency? If you don't put it on at all, how are you clinically acknowledging what the patient is really doing to help control their own symptoms? So we began this conversation, and then I reached out to another member organization who I thought, well, let's call someone who has a little bit more experience dealing with marijuana. So I called a leader in Denver. And she sort of giggled, and she said, well, actually, since now we don't call it medical marijuana anymore, we're a little bit post those issues, and our issues are now about what do we do with our employees? Since this is now a recreational product, how does it change our employee relations? And that opened up a whole new level of conversation, and that is where I was able to, through a series of connections, start a conversation with Daria. And as we began to talk, what we just kept coming back to is the myriad of things we do not know. And thus the question, what is marijuana to us in home-based care? Is it a street drug? Is it a medication? Is it something else? So what we're going to try and do today is introduce a few of the issues around the clinical care of patients using marijuana, around the legal issues, and that is very complicated. And then we're going to end up talking about where the legal and the clinical meet, which is the operational issues for a home-based care agency. And at that point, I really am going to invite all of you to take part in the conversation, because I'm assuming most of you are coming from different states and have different experiences with this. So please feel free to join in. So to get us started off, I thought we would talk just briefly about clinical and the plant itself. So this is our cannabis plant. Yay! So the cannabis plant gives us two primary products. The first is marijuana. And just so we're all on the same page, and I'm sharing things that I learned in developing this, marijuana is actually coming from the flowers and the leaves. So when the plant is grown, we pick the flowers and leaves and dry them. Maybe not we, but they get picked and used to make a variety of products that we call the whole family marijuana products. The alternative product is hemp. And hemp is really made from the stems. And that is because it's a fibrous product that can then be, that strong fiber can be used in things like clothing and paper and rope and things that really require a strong fibrous product. So we have two different product lines that are coming out of the same plant. And one of the reasons that that happens is because they grow different strains of the plant. Well, that has some clinical implications for us as well, because in addition to the difference between the stems and the leaves, and in terms of their fiber, there's also differences in the chemical compounds that these different types of plants exhibit. And here's one of the great things that we don't know. Mostly, we don't know much. Since cannabis and marijuana has been listed as a Schedule I for so long, there is very, very, very little research into what this plant does and how it interacts in our bodies. And this has huge implications for us from a clinical perspective. We know a couple things. We know that there are chemical compounds within the cannabis plant known as cannabinoids. I'm going to have a hard time saying that over and over. And we know that there are lots of cannabinoids. We don't actually know how many there are. Depending on what website you go to, you will see them talk about anywhere from 2 to 20. And we know very little about any of them. The two primary ones we know about are THC and CBD. And then this third one is starting to come up as CBN. So these are the chemical compounds that actually interact with receptors in our bodies. This is another thing we know very little about. We do know that there are cannabinoid receptors within our bodies, and we know that there's at least 2 different types, but we don't really understand them, and we don't really know, is it only the 2, and we don't really understand how the compounds, the THC, the CBD, and all of the others that we haven't yet named, how they really interact. We have some general ideas. We generally know that THC works primarily on what they're calling CB1, as a cannabinoid receptor 1. This is primarily the psychoactive and effects of marijuana, so the things, oh, it calms me, oh, it makes me anxious, oh, it makes me happy, oh, those sorts of effects, because the CB1 is primarily found in the central nervous system and basically in the brain. So things that affect experiences of time and memory formation and appetite, actually, are primarily related to CB1, which means it's primarily an effect of the THC. The second receptor is CB2. That's more peripheral, and it's more within the immune system, and it actually is the one that affects nausea. It's on the HT3 receptors, so any of the nurses in the room are going, oh yeah, Zofran, good stuff. Well, that's actually the other cannabinoid. That's the CBD. And so what we understand is that the plant itself can be grown to accentuate different cannabinoids. Do we want the THC or do we want the CBD? And that has implications for what product the patient might be using depending on what they're trying to impact. And these are all things that we don't understand really well. And these are things that have a very significant clinical implication when you're trying to go into a house and talk to a patient about what are they doing, how are they doing it, why are they doing it, and is it working or not? And how much they understand about what product they're using can pretty dramatically shift how it is affecting them. And I think that this was really startling to me, to think that I could go into a house and try to be talking to someone clinically and understanding, why are you using this product? What does it do for you? And have them really struggle to say, well, sometimes it works and sometimes it doesn't. And that's because it's all kind of unknown. And that is very concerning to me as a clinician, that I really have no predictability in being able to understand what is happening. To make it more complicated, we can then take that plant, those dried leaves and flowers, and we can turn them into a bunch of different things, and the delivery method matters. So primarily we talk about marijuana coming in inhalation methods with people smoking a joint or a bowl or whatever other varieties people want to use. That's the most common, is inhalation of the smoke. But it's not the only way that we can utilize the marijuana. Marijuana, the stems and leaves can also be turned into a powder. The powder can actually be ingested as it is, or it can be mixed in something else. The powder can be then made into balls. The balls, hashish, can then be also ingested or re-smoked. It can also be vaped. I'm not even entirely sure how you vape as opposed to smoke, but apparently you can do all of these things. You can also get the oils out of the marijuana leaves, and that oil can then be used in a multiple of ways. It can be mixed with various carrier fluids, anything from literally dairy butter to a glycerin, and then it can be put into food products. This is how things get made, like candies and lollipops. It can be put into skin creams and absorbed topically. And so all of these products are available to us, and all of them have to be part of the assessment when a nurse goes into the house and starts talking to people. But that's about where things stop, because we have no real way to understand what are the active properties in there, how much of it is in whatever product they're using. And it's really a completely unknown beast after that. So having completely illuminated that area of grayness for you, I'm going to ask Daria to help us understand the legal complexities we're facing.
Just the arrow button. Yep. Okay. Yeah, just what you need when you want clarity, a lawyer, right? Marijuana legality, illegality, gradations of legality are all over the map, literally, of this country. So there are several categories. Either it's, and we're talking on the state law basis, we'll get to the feds in a moment, but so from a state law perspective, it's either illegal but decriminalized, permitted for medical use, and or recreational access. What's decriminalization? That means it's a civil infraction or a misdemeanor. Think of a speeding ticket of the worst variety, things of that nature. And as you drill down into the different state laws, the infractions in terms of what type of a misdemeanor it is probably vary in terms of the circumstances of the possession or use. And recreational can be decriminalized even though it is not legal in states where medical use is permitted. And I've put some examples on the screen. Medical use only seems self-explanatory. I've put an asterisk by states where the medical use is really severely restrictive and restricted. For example, there may be a state where a qualifying condition, and I'll get into what that is in a moment, might relate to only one or two types of illness or conditions. Legal, and I put that in quotes because legal still comes with restrictions, are the states listed here. I'll note for Massachusetts, and this is a good way to point out the complexity. In November, the people of Massachusetts approved a ballot question to make marijuana legal. It was a very long and complex ballot question, but now the state has to promulgate regulations to figure out how to implement that ballot question. And our legislators are saying, wait a minute, we want to take a look at the whole thing. The voters have asked for legalized marijuana for recreational use, but we think we can perhaps do a better job of rewriting the legislation. So, to be continued. Are you from Massachusetts? I see someone here kind of laughing at that, and it's true. It's really very interesting. So in the 17 states that have legalized medical marijuana, use of low THC, have not legalized rather, use of the low THC products that Danielle was discussing for medical reasons in certain situations is either permitted or available as a legal defense. Just want to make sure I'm not getting ahead of myself here. Okay, so some states have legalized recreational marijuana, but give local governments the option to prohibit recreational marijuana in their jurisdiction. I put Colorado and Oregon as examples, Massachusetts as well. Cities and towns can restrict by a certain vote recreational marijuana if they don't want it. It's a bit different for medical marijuana. In that case, you could put a moratorium on dispensaries until you figure out how you're going to zone them, et cetera, but the Attorney General said you can't completely prohibit them. And again, some states that have not legalized medical marijuana have specific exceptions. Alabama and Mississippi permit it for severe epileptic conditions. Pending legislation is all over the map again. So we've got decriminalization bills pending. A decriminalization bill failed in Wyoming. Bills that would amend existing marijuana civil penalties are pending in Maryland and New York. And there is a map. I didn't include it here because of those pesky copyright laws, but if you go to that website, you can find a map. I would like to caution you, though, if you're trying to do your own research about marijuana and legalization of marijuana, I found so much information on the internet that was just wrong. So you really do need to be very careful. I'm not sure if you found the same thing on the medical side, but also if your IT department is watching, you will get a lot of security warnings, et cetera, et cetera. So they're kind of used to me, but you know, in any event, I do call that out. Federal law, this is where it gets interesting and where there are real challenges for healthcare providers, particularly in states where there has been legalization of use for medical purposes. So as we know, cannabis contains THC, which is a psychoactive substance. It's in Schedule I under the Controlled Substances Act, meets all three prongs. Advocates for the medical use of marijuana will tell you that the reason why it's in Schedule I is because there is lack of accepted safety, lack of information, and the lack of information is because it is in Schedule I and we can't do the research that we need. So that's the first cyclical path we'll talk about here in this presentation. So federal law is pretty darn clear. It's illegal to manufacture, distribute, dispense, possess with intent to manufacture, distribute, or dispense a controlled substance. And state law, in this case, does not override federal illegality. So that has a lot of implications. It has implications for me. I would like to keep my license to practice. I would like to avoid jail. Or other sanctions, and I would assume that those of you with nursing or other medical licenses would feel the same. So you may hear talk, and now we're going to get into the federal enforcement of marijuana and what, if any, changes have occurred or are anticipated to occur under the Trump administration. So you may have heard about the Cole Memo. That may ring a bell for some of you. It's actually a series of memos, but the third guidance memo regarding marijuana enforcement is what people typically refer to as the Cole Memo. And basically what the Cole Memo says is, and this was issued by the Department of Justice, is the Department of Justice is going to prioritize their resources and efforts in enforcing the Controlled Substances Act regarding marijuana. They're going to target their activities to prevent distribution to minors, revenue going to criminal enterprises, gaming organizations, organized crime, and cartels for what essentially has to be a cash business. That's a little bit of an issue, but we'll talk about that. And here I put in the diet version, the updated thing didn't make the slide deck. this is what happens when you copy from the internet. This was a reputable legal source, the diet version of marijuana from states. I went back and looked at the memo. It's the diversion of marijuana from states, where it is legal under state law in some form going to other states. State-authorized marijuana activity from being used as a cover or pretext for the trafficking of other illegal drugs or illegal activity, and violence and the use of firearms in the cultivation and distribution of marijuana. Drugged driving, exacerbation of other adverse public health consequences, growing of marijuana on public lands. I'm not sure who's doing that, but I know way back there were aerial photos of marijuana being grown on state parks. That might be what they're thinking about. And possession of or use on federal property. Now, states that have legalized marijuana in some form, the DOJ says they're less likely to be threats to our priorities because theoretically they're going to have strong regulations and frameworks in place to regulate the growth and distribution. And the Cole Memorandum gives the DOJ wide prosecutorial discretion to decide whether to prosecute state legal marijuana enterprises. So let's stop on that one for a minute. So just think about the implications for those who are trying to set up marijuana dispensaries and businesses. It costs millions of dollars to do that. This is not a cheap enterprise. You think of weed. I may be dating myself, but it would grow anywhere. That's why it was called weed. Well, apparently, this happy little plant is not so happy in a controlled growing environment with lots of other little plants. It's a very delicate plant, very susceptible to pests and fungus and all sorts of things that make it difficult to grow. So there's discretion. We may change our minds. That's cold comfort to people who are trying to set up these dispensaries. And it's probably not an efficient use of federal resources to focus enforcement on state legal businesses. Now, when Trump took office and appointed Attorney General Sessions, who is widely outspoken as opposing legalization of marijuana, I think a lot of folks were bracing for, okay, no more marijuana, shut it all down. But in mid-March, he said the Cole Memo set up some policies and which cases would be appropriate for federal prosecution, much of which I think is valid. So I think the message we're getting from the Department of Justice and from Attorney General Sessions is we're not going to do anything about this for now. I would suspect that at some point the Department of Justice is going to be hearing from the IRS, because I said this is largely a cash business, and particularly in those states where it is legal, trucks with cash to pay taxes going to the IRS. I don't know that the government has thought that far ahead or has a mechanism in place to deal with that. No prescription. That is a really important point when we're talking about medical marijuana. I can't tell you how many times someone says to me, well, if I have a patient who's been prescribed marijuana, doctors and nurse practitioners cannot prescribe marijuana. It's against the law for them to prescribe marijuana. What they can do is certify that a patient has a condition that under applicable state law enables the patient to obtain marijuana for medical use. That is a huge distinction. A lot of doctors don't want to even certify. Various group practices are taking up policies, et cetera, in terms of are we going to do this, are we not going to do this? And that has resulted in a lot of specialty practices that assess pain management and others, quote unquote marijuana mills. You go in, you get a card. Most states require that there be a bona fide doctor-patient relationship with the practitioner who is certifying the condition. How do you establish that? There's a lot of gray area in that regard, and I think that In states where medical marijuana is legal, I think that the licensing boards are taking a look at that. In some states, nurse practitioners can be the certifying provider. I know that in proposed amendments to the Massachusetts regulations, they are proposing to add nurse practitioners to the list, to physicians to be able to certify. So now we're going, that's the landscape. Now we're going to start to get into some of the questions. And I think for this, I'm going to sit down and we can try to have a little bit more of a discussion. And I have to say that preparing for this with Danielle was really enjoyable because I talked to my healthcare colleagues and I talked to people I know in the cannabis industry, and I've never before had that intersection, if you will, of the two issues, because my primary practice is representing healthcare providers who I think are just now starting to think about some of the questions that we are going to discuss. So the only problem with that plan, I'll stand up for a while, and can we have a clicker? Excellent. All right, we have the technology. All right.
Can you make it awkward?
There you go. Okay, so let's start talking. Thank you. About some of the clinical legal questions. And when Danielle and I were preparing for this, the list of questions just kept growing and growing and growing. And through some conversations with people today, we've had other questions come up. So it really is a bottomless pit. So the first slide of clinical legal questions, you walk into a home and the patient says, I have my certification card. First of all, how many of you are in jurisdictions where medical marijuana is legal in your jurisdiction? So a lot of you, okay. How many where it's also legal recreationally? Okay, all right. So for those who are listening, the vast majority of attendees here, I guess it should come as no surprise, are dealing with this now and maybe in the future. So, what do you do with the card, Danielle? Do you as you're recording your patient visit and taking your history and figuring out the patient's clinical condition and how they're managing their pain and looking at perhaps other prescribed pain medication, where do we put that? Can we ignore it? Can we pretend it doesn't exist?
I think this is where we get super complicated because it comes into multiple issues of documentation of what's happening. One of the most important parts is this is not a prescription. And if we even attempt to put it on a medication list as a medication, we'll talk about the ECR limitations in a minute, but the reality is if you list it as a drug on your drug list, it's going on the plan of care to a physician. If a physician signs it and sends it back, you know which physicians are not reading your plans of care. Those who read it are not going to sign it because they are not prescribing the drug. And that's going to cause problem. You also have a problem in your ECRs, right? Most of our ECRs are fairly prescriptive, where you're filling in boxes, not doing a narrative. So I don't know how you put in the box that says drug name, dose, frequency, route, indication, smoke a couple joints when you feel like it. I don't know how that fits. So the closest in the conversations that I've been having is maybe we can list it as an herbal or an over-the-counter in the next section. And even then you run into technical problems again because our ECRs are set up for that data entry that has those standard components of a medication, even if it's an over-the-counter Tylenol. You're still supposed to put in those categories, which really don't fit. So some people actually run into challenges with even getting the drug on their list. Please.
I'm just thinking, the problem we're having here, if we're getting into the weeds, when you have the general issue of symptom management, and if you go into the risk reduction, or if you go into, and as you know, as a lawyer, your job is to advise others how to reduce your risk. Mm-hmm. But I don't think that's going to solve our discussion for today. I mean, I think having all the issues are very, very important. But the bottom line is, if the patient benefits from marijuana in a state that allows access to it, then the question really doesn't make any difference where you put it, because no matter what you do, you have a risk. And so the ultimate thing is, I mean, shouldn't we be looking at the landscape and say, how do we manage this in a way that benefits the outcome? And section, or whether it's in the narrative, or whether you put it in the herb, or whether you put it in the weed section of your EMR, you need some flipping. I mean, I guess what I'm trying to challenge us to think about is, the reality is marijuana is being used by X number of patients, we're overseeing, and the question is how do we manage it?
I would agree completely. I would say that some of these details, though, do matter, because as you're talking to your teams and trying to work on team-based care and communication and sharing what is happening with the patient, we do have to have some way to consistently communicate what is that patient doing. And these are the structures that we currently have, which don't fit really well for this situation. And these are just the structural components, because as I started the presentation with, there are a lot of clinical challenges in, okay, so even if I don't try and figure out how to document this until I get back to the office and call my boss, which is probably what's going to happen, there is still the question of how are you using this, when are you using, how much of it are you using, how does it interact with the other medicines you're using, and how do I as a clinician understand this product that, one, we know very little about, two, in nursing school, did anyone actually talk about it? No, of course not. So we collectively don't have much knowledge on it. And it's very, very difficult to try and sort out what are the clinical implications of this. And there is a legal obligation here for the agency because it's very complicated. And I think that some of these questions around the structural component of where do you even put this stuff, and do you include the recognition of a patient's card? What happens if you're in a medical state, but your patient is using the product without a card? You know, now we're kind of back to, I don't know, 5 years ago, before we started having medical marijuana being so prominent, and back in that question of how do we as clinicians support and acknowledge what our patients are doing in a way that reduces our legal risk but honors their choices. And now we start to get into really complicated areas.
Right. And to your point, I think in one aspect, the legal nitty issues overlap with the patient care issue, because you need to make sure that you have a complete picture of your patient's status and needs and conditions. And you need to be sure that you document that in some way. And you need to do that to make sure you're taking care of the patient properly, but also if there's a question that comes up later, you need to be able to have a complete record of your visit and your guidance. One of the questions here, how do you assess, whoops, you flipped to the next slide, or that's right. Yeah, where do you document, who can, I'm lost on the slides here. Go back one. Okay, sorry about that. So is it ever an unsafe condition? One of the attendees here brought up a very good point. What if you have somebody who's home and they're on an oxygen tank and they remember the 60s and the 70s and they want to smoke their cannabis? I know that's patients even sneaking cigarettes in skilled nursing facilities is a huge issue, and you could have some significant accidents. How do you counsel about that? One of the issues about marijuana, whether it's obtained from a dispensary or homegrown, is its purity. If you have someone who's immunocompromised and they're self-medicating with marijuana, how do you know, how do you caution them about whether the product is safe, free of molds, contaminants, and other things that their already weakened immune system really can't deal with? Is there, what's a registered, let's go to the next one. Oh, do we have to report it? That's another thing. So what do you mean, do I have to report it? To whom? So if I go into a home and there are small children around and mama's high as a kite, my patient, on marijuana, I don't know, what are your reporting obligations there? If you walk in and you see one plant, do you have any reporting obligations? If you see 50, do you have a reporting obligation? It gets very, very dicey. Okay, if patients use and drive, is the agency responsible? And to Danielle's earlier comments, there are different strains of marijuana, different products. Are they using a marijuana strain that is going to cause them to have motor or judgment impairment, or are they using a low THC strain that won't?
And how do we discern between being high and being positively impacted? There's at least anecdotal evidence that tells us or suggests to us, I'm trying to be careful in my use of scientific words here, but at least suggests that over time, the stoned effect, the psychoactive effects may wear off as people become accustomed, which is something that those of us who work with long-term use of other opioids are familiar with. But we don't know for sure that that's true. And since we have no real control over the amount of THC in any particular product, whether it is one joint to the next, what is our confidence level in that whole idea? How do we have any sense of where is the safety line here? And how do we help our clinicians to interact with that? I think particularly in today's conversation around the excessive use of opioid narcotics, we've sort of swung the pendulum in this country for a couple decades. We were really working very hard to say no pain is okay, and we were prescribing a lot of medication to a lot of people for long periods of time. And now we've recognized that that's created a secondary problem, right? We talk about the opioid crisis in this country. So we have a lot of mixed messages over how do we use these medications, when do we use these medications, and clinically, how do we help people sift through some of this information? And I think that all of these things are very, very confusing, primarily because we're not talking about them yet. And that is part of probably one of the main goals of this session, was just to start some conversations, because neither Daria or I can give you, here's a clear answer. But I think as industry leaders, we need to start to have some of this conversation and start to think about what would we advocate for and how would we guide our clinical teams, because I think one of the worst things that as an agency leader I remember was when I would find out about a situation that the frontline team was managing long after they'd been managing it. And the anxieties were high and the risk was high and people were worried and scared, but they didn't talk about it up front. And I think we have a lot of risk around that issue with marijuana, no matter what kind of state you're in.
I will have some clear answers on the employment side, though, in a few minutes, so you're going to get your money's worth on that. So the last question, a couple of questions. Does the doctor actually know? I would bet that in a lot of cases, the doctor who is really the primary caregiver is not the same doctor who issued the card, who certified the patient. So that's an important fact to know. And that goes back to the documentation issue. Even if that doctor didn't certify, that doctor should know the patient's profile. And then I'd like to talk a little bit about the concept of a registered caregiver. So a registered caregiver, it's defined differently in the different states where medical is permitted. But essentially, it is someone who can register, as the name suggests, as a caregiver for a person who has been certified to have marijuana. And the purpose of the registered caregiver is to facilitate getting the marijuana to and administering the marijuana to the patient as part of the care. In most states, the caregiver cannot grow for the patient. In Maine, the caregiver can grow. And most states will limit the number of patients, I've seen between 3 and 5 typically, as to how many patients a registered caregiver can have. Now, advocates for the use of medical marijuana obviously see the benefit for patients and want to make sure that the fact that a patient can't get up and drive to the dispensary doesn't bar that patient from access to medical marijuana. Now, in some states, there's the concept of an institutional caregiver, so a hospital or a skilled nursing facility can become an institutional caregiver, register its employees, and the institution can facilitate that for its inpatients. Home health and home hospice agencies are not considered institutions. It goes back to the personal caregiver. But are you, or has anyone felt pressure from perhaps a state where there is the regulatory ability to have home health workers be a personal caregiver, to do that? And I think a lot of the state regulators and advocates focus on that and forget that you're asking a home health agency that receives federal money, Medicare, Medicaid, all comes from the feds, or at least in part on Medicaid. Everybody has a license. Some may have a DEA number. You know, how do you reconcile that? So that is a, I think, a real issue. I've had some offline conversations with folks on the regulatory side and said, how is this actually going to work? And I don't know that anybody really has a question, the answer to that.
I'm going to push that even a little bit further. Remember how we talked about variety of delivery and different products? I think there's a really different thought process here if we're talking about, is the home care hospice team going to take part in helping someone light a joint versus it's in their cream, it's a topical, it's in a pill form. Those have some pretty different, I think, instinctual reactions. You know, we still have debates about whether we can delegate medicated cream to non-licensed staff. And now we have the possibility of people having a cream that has marijuana oil in it. You know, and some of you are going, oh, you know, like how do we provide guidance to our teams about this? How do we help them to just process the situation if we haven't even started to think about it ourselves yet? Yes, please.
We were approached, the dispenser for marijuana. So we started to look into this because we're looking for other sources of revenue in our industry. So when we went to check it out, we exactly found out that because we accept federal funding, that would put us at risk of losing federal funding, so we shouldn't do it because our state is not legal to do that. So, you know, we dropped out of that ballpark. But when you talk about it's a class 1 drug, so who would want a home health aide or a paraprofessional administering a class 1 drug? Not me, I'm a nurse. I wouldn't want that to happen. You know, there's conflict amongst our industry about that. But,
Right.
I think we just need to be careful.
Right. Because you're thinking about it as the nurse does and thinking about it as a drug. But when we come back to it at its core, it's not really a drug because we don't prescribe it. It's kind of an over-the-counter. And that's where
Is alcohol a drug? Okay, so if alcohol is a drug, then marijuana is a drug. I don't care what the prescriptive practices are. It's a drug.
And
There's your state of being, and it controls pain.
so does the culture support that? Or is the movement that we're heading into where this is a product and not a medication change the way, would it change the way that the decision of the person in the home, would it change their decision if we haven't talked about it in advance from an agency perspective? Do you know, it's like if people in the home are going to make the decision in the moment, if we've talked about things like that, we provide agency-based guidance on what they are. And I'm not sure that we're all talking about what would our expectations be for this brand new thing that we're not really sure what to do with yet.
And to your point, you know, you raised alcohol, and on the next slide, we're asking about informed consent to have the cream applied or to assist with cannabis. How do you educate about cannabis? What is your agency going to do? I think one of the risks, and it's an inherent risk in having a home health agency because your providers are not in-house where you can look at them. They are out doing their own thing. And I think that agencies need to have a clear directive and policy, even about, what will we administer, what won't we, down to how will we show things in the clinical record. And, let me ask you this, as clinicians, when you're, getting the background of your patient, do you ask about alcohol intake? How many drinks do you have? I'm seeing all the heads nod. So let's say you're in a state where recreational is legal. Is this any different if rec is legal than in terms of documentation than documenting how many glasses of wine a person has a day? If you're looking for maybe problems with the liver or interactions with other medicine that they may be taking. So, separating recreational versus medical use is going to be challenging as well. What about your licensing board? What do they have to say? From my research, not a whole heck of a lot. And for lawyers, this was the case as well. When I first started advising clients in this area, the Massachusetts Board of Bar Overseers was very silent on this, and thankfully I worked for a large firm, and we felt that we were helping our clients who were interested in this business comply with state law, and eventually the licensing board came out with something that says as long as you're doing that and counseling your clients that it's still illegal on the federal side, you're okay. But what do you do as a nurse? And by the way, if you decide you want folks to be registered caregivers and go to the dispensary and bring it back, what about their safety and security as they leave that dispensary with the substance and try to get to someone's home? So you should be on the lookout for guidance, regulations, directives, smoke signals, anything, no pun intended, from the nursing board to really try to figure out what the directives are. This is an easy one. See, I told you I'd have an easy one. One question that had been asked are marijuana dispensaries HIPAA covered entities, and the answer is probably not because they can't, they don't bill electronically. So I would say the answer is probably not. Yep.
From the professional nursing organization perspective, the ANA and HPNA, Hospice and Palliative Nurses Association, both have statements. They're both a little bit old, and in general, they basically say we support more research and understanding. And so they're pretty bland in providing us guidance in terms of any of their real practical information. I did also discover that there is such a thing as the American Nurses Cannabis Association. I didn't know that before, but there is a group of nurses out there who have formed an association, and their commitment seems to really be around providing education and providing information for other nurses who will be caring for people who may choose to use cannabis. So they're a small organization, but they are out there, and they offer an opportunity, at least, for us to get some information. It was where I learned a lot about the pharmacology issues.
Where are they getting their information from?
That's an excellent question. What I recall of their website, they were referring to multiple federal studies. There are actually a couple studies that have been done through the Institute of Medicine. And there is a research group out of the University of Mississippi. I don't know if they're the only one, but if not the only, they are the primary place in the country that is actually allowed to do research with marijuana. They have this big, high security vault. It's pretty impressive. There are actually YouTube videos. Go check them out. That has the approval for doing the small amounts of research. So that is where what I recall of their reference list. But at least there are some nurses who are out there saying we should know more about this.
The cards that they are they, I don't know what a legitimate medical marijuana card look like. What does it look like? Are they different state to state, or?
Interesting. I don't know. I think it's almost like a driver's license type thing. But I'm glad you brought up that question, because one big issue that has come up in some of the public hearings in Massachusetts to amend our only several years old medical marijuana regs is the length of time that it takes once you submit to get a registration card. Typically is longer than the average hospice patient lives. So the average length, the average hospice patient in Massachusetts, the average, the length of the hospice care is 30 to 45 days. So it can take longer than that to get a hospice card. So advocates are really trying to get that process speeded up and also to reduce the cost. One other thing, we're starting to run out of time. Applause from the other room is always a good sign to know you've better speed it up. But you're all employers, and I wanted to just touch on this a little bit. Generally speaking, there is no obligation to accommodate an employee who says that they are using marijuana, either in a state where it is legal recreationally, or if they say, I have XYZ, condition and I'm using marijuana. The Colorado Supreme Court, in fact, ruled that a pot smoking employee can be fired even if it's legal in the state because it remains illegal federally. And there is generally no obligation of an employer to accommodate use of medical marijuana in the workplace. I mean, that's a little bit clearer, but what about off-duty use? And there's actually a case pending before the Massachusetts Supreme Judicial Court where a woman was fired from her marketing job after failing a drug test despite possessing a valid marijuana card to treat Crohn's disease. And she sued over alleged employment discrimination and unlawful termination. The claims were dismissed. And the court didn't dismiss her claim that the drug test was an invasion of her privacy, but noted that the situation is different for safety-sensitive occupations. But Barbuto appealed, and her case is now pending. It was heard in March, and we're expecting a ruling at some point. So that will be very interesting. Another employer question: what if you decide as an agency that you want your agency home health nurses to be personal caregivers? And I'm one of your employees, and I say, that's great, I'm glad. I refuse. It's illegal federally. Okay, so can you terminate that employee for not wanting to violate federal law? What happens if at some point the feds or a local nursing board does decide? What's your responsibility? It's very, very dicey. The one thing I will note is that I think that all of us as leaders in the medical legal profession really need to start getting a handle on this. Because I don't know exactly how prevalent the issues are. I know that hospitals are already struggling with, Jane manages her pain at home by smoking marijuana and then, is doing just fine, gets admitted to the hospital where not only is marijuana not allowed, but you can't smoke either. I don't think the no smoking signs say except for marijuana. How do hospitals manage that? Are they really going to say, well, we're going to put you back on an opioid pain medication because you can't have the marijuana here? I don't know that that's in the best interest of the patient. But certainly, no one wants to be in violation of federal law either. So there are a lot of concerns. I won't even get into the banking industry and the risk that poses. Essentially, banks aren't supposed to lend to marijuana industry. They're not supposed to take money gleaned from providing cannabis. And they are supposed to file what's called a suspicious activity report if they are getting deposits that they think have come from the cannabis industry. If there is a state where medical or rec is legal, that is downgraded to an informational suspicious activity report, but still. So I think there are a lot of open issues, and I do think as the number of patients grows that's using cannabis and cannabinoid products, or MIPS, and marijuana-infused products, which do include frozen pizza, by the way. I'm not kidding. Frozen pizza. Yep. That we will really start to face this, and we should probably start to try to figure out how we and how you as home health and hospice providers want to face it, because I think that if you don't shape it, somebody's going to shape it for you, and I would predict that you might not like the result as much as if you'd had more input.
I think that's pretty much the bottom line here, is that we hope that in this hour we illuminated for you some of the issues that have not been discussed, and are at least are not being discussed widely, and in the goal of starting to open up this conversation. So thank you all for being here today. I do want to thank Daria for joining us from Boston.
Thank you. It's been a pleasure. Thank you.
And please take a brownie.